Right. So I see we've got some material in front of us.
Yes, so this answers the question that Lady-in-Law asked earlier this morning. So I have printed.
Mr. Karim, I'm going to let Mr. Malik, as soon as he has, rightly, that we'd like to hear a little bit further on this. We've all been looking at the Mero outside as well, independently. So
yes, so,
yes.
So I've printed the explanatory memorandum to
Yes, thank you very
2018
much.
amendments. The relevant paragraph is paragraph 7.9.
We don't have to worry about anything else, though, do we?
Sorry?
We just look at 7.9.
7.9, yes.
Let's read that.
Perhaps just the first sentence of paragraph 7.9.
Yes.
That's that.
And it is, in fact, the CJEU judgment in case C424, I think, isn't it? Just out of curiosity.
Yes, so the
It's a
second
misprint.
yes, so the second document that I've ended up is the Supreme Court's judgment in Vermeer.
Second time after this.
Yes.
Post-date, yes?
So if you look at the Supreme Court's judgment, you see the questions that were put to the court at paragraph 21. And the first question was whether the enhanced protection depends upon the possession of a right of permanent residence. And the court essentially said that, yes, that is the case.
That is the question to the CJEU. Yes?
Yes.
And the answer we've saw was on page paragraph 25, isn't it?
Paragraph 25, within the
26.
quotation 47, 48, and 49.
And summarised at 26 in the Supreme's Norway's judgment.
Yes. May I just flag what is said at paragraph 48 of the quotation so that my learned friend may respond to it. So the focus was not only on the wording of Article 28, but also the structure.
Yes, the gradually increases. Sure. Gradually increases in proportion
To the degree of integration of the union citizen, concerned in the host state.
It's a cumulative process.
Yeah. That must be consistent with the submissions that I was seeking to make this one.
Thank you.
Very good.
Thank you very much, Mr. Malik. Yes, now, Mr. Kareem, thank you.
Thank you, my lady, my lords. I believe I left things at recital 24
You did.
in the authority bundle.
Please, let's get it back.
Page 6 of the authorities.
Yes. Yep.
And there I was making the point that the recital recognizes that where the residence has accrued for many years, exceptional circumstances apply essentially. Moving on quickly to Article 2 and 3, 7 and 8 of the authorities bundle. We have a definition of union citizen and family member. Article 3 confirms the beneficiaries, which are the three classes of people I referred to earlier on: citizens, union citizens, family members, and other or extended family members. Next, if I may take the court to page 15 of the authorities bundle,
Yes.
Article 16.
You're moving on. You're not saying anything about Articles 6 or 7.
Not at this stage, my lord, no.
Yes.
16.1, union citizens who have resided legally for a continuous period.
Yeah. What does that mean?
I stress legally and for a continuous period. Legally means essentially in accordance with what Articles 6 and 7 say about exercising treaty rights. Working.
So that means in accordance with the directive, does it?
Yes, so the mere presence in this country doesn't eventually lead to permanent residence. One has to be exercising treaty rights, quote unquote, which includes, for example, working, being self-employed, or there are other categories as well, study, I believe, etc.
Yeah. But just underlining the point. What that means in Article 16 is union citizens, which we remind ourselves again,
Article 2.
any person, a person having the nationality of a member state who has resided under a right vested by Article 6 and or 7.
That's right.
For a continuous period of 5 years in the member state.
Subparagraph 2 talks about the family members, as long as they've legally resided with the union citizen. So the example my learned friend gave about an Indian student who comes here, spends 4 years studying, and then marries in the 5th year. Well, he hasn't resided with his EEA family member for a period of 5 years. So that example would never lead to permanent residence on the 5th year. It would be perhaps on the 9th or 10th year, by which time that person would qualify.
All right. So just help us with how does this apply in the case of somebody of your client's circumstances?
Well, actually it doesn't, because he already obtained permanent residence as a family member in 2007. So the question of whether or not he has permanent residence never arises in this case. The reason I'm taking the court to it is because of the language used, where it talks about resided legally and for a continuous period. And what I'm trying to do, hopefully, is to draw a distinction between that language and the language then used in Article 28, when it talks about the top tier protection.
Yes.
Can you remind me, is there an authority, and if so, where have we seen it, about the meaning of the word legally? You say legally means exercising a right under the directive, or a treaty right, or some sort of right. I think we've seen something. Maybe it was something.
I think that's common ground between the parties.
I asked Mr. Malik it, and he
Yes,
said yes, and you agree. Is
I
that
can't
right?
immediately point to an authority off the top of my head.
I've seen something over lunch, I'm afraid that's not right. Okay. Maybe there's some reference to it, I think, possibly in
Ramiro.
somewhere in some of the debate.
Both sides agree at the moment that it means residing in accordance with the provisions imposed by the directive.
But just to flag up, Article 6 and Article 7 envisage that the individual will have been a union citizen from the word go of the residence, doesn't it?
No, my lord, with respect, I don't think it does, because Article 7(1)(d) talks about family members as well. So it's not limited to union citizens per se.
But 6(1) and 6(2), 6(1) and 7(1).
Well, 6(1) and 6, the way that these provisions have been drafted, the way I see them, is that they first refer to the union citizen, and then they talk about the family member after that. So obviously, in the absence of a union citizen, no rights arise, as it were. If there is no union citizen, the family member doesn't have a right initially. But of course, events may lead to that family member obtaining rights in their own right, as it were. For example, if the union citizen passes away, or there's a divorce, or they're a victim of domestic violence, etc., etc. But the way I read these provisions is, initially it refers to the union citizen, and then of course the family member is tagged onto the union
Maybe the
citizen.
answer to your question. Maybe the answer to your point you were discussing.
That's right, and I think the it's clear in Article 6.2 that the family members do not need to be nationals of a member state. I mean, does it follow that where that qualification isn't made, you can assume that they're talking all the way through about people who are union citizens?
Yes, because if they were a family member who had union citizenship, then they wouldn't be a family member. They would simply be a union citizen.
Exactly.
So if, for example, couple A and B are both EEA nationals of different countries, then B would never essentially be a family member because they're a EEA citizen or union citizen in their own right.
So your submission is the whole point about the family member provisions is that they enable people who are family members of an EU citizen, to use that shorthand, to come here even if they are not nationals of the EU.
Precisely.
And acquire the rights of residence cumulatively.
Precisely. And that's not limited to dependents under the age of 21. Even once a child reaches the age of 21, there may be circumstances where dependency continues and they remain a family member. For example, someone who's severely disabled or doesn't have the mental capacity of an adult, although physically may be an adult, etc., etc. So the 21 age thing is not necessarily a cut-off point.
Well, that comes from the definition into Article 2.2c.
Precisely.
Direct descendants under the age of 21 or are dependents.
Precisely.
Thank you. Right. Sorry, I
Bearing in mind what
interrupted you, Mr. Kerry. You
Not at all.
took us to Article 16.
Yes, and I
About
emphasised
legally, and you
legally and
said
for
what you said
continuous
about that.
period.
Yes.
If I can then take the court to...
Sorry, if I could just interrupt, just to test your submission, please, Mr. Cohen. So, on your construction, does somebody who has resided legally for a continuous period of 5 years in the host member state have the right of permanent residence if they become a citizen of an EU member state or in the last month of that 5 year period?
If they were prior to that 5 year period a family member, then yes, it's all accumulated into one period because they've been here as a family member legally for a continuous period, which may end, for example, with them spending a month or 2 months as a union citizen.
Your submission is consistent in any event. All right, thank you.
The next provision is Article 27. Again, I don't intend to spend much time on this, but it says 27.2 measures taken on grounds of public policy or public security shall comply with the principle of proportionality, shall be based exclusively on the personal conduct. ... And then Article 28, this is where we have the 3 tiers of protection against expulsion or deportation. Tier 1 is at paragraph 1, Tier 2 at subparagraph 2, and Tier 3 at subparagraph 3. That says an expulsion decision may not be taken against union citizens except if the decision is based on imperative grounds of public security as defined by member states, and I stress as defined by member states, if they have resided in the host member states for the previous 10 years. No reference to continuous, no reference to legally, none of that. And that omission, I say, is an important one. That is why I took the court to Article 16 to emphasize the use of legally and continuous.
Where sorry, remind me which article you were looking at just then. I was just...
This Article 28.3.
Yes.
And I invite the court to compare the language used in that provision to Article 16.
But can you be said to have resided in the host member state for the previous 10 years if you haven't been living there continuously?
Well, continuity isn't, for example, broken if you leave the country for a period of up to 12 months, I believe, or something to that extent. It does define that elsewhere, so that's...
Well, hang on, you're saying that seems to imply that some form of continuity is necessary.
Well, I say it's not necessarily because the tenure can be made out of different periods combined together.
I see.
So what is the difference in your interpretation? Is there a difference? And if so, what is it between Article 28, 2 and 3?
Well, 2 applies to those who simply have permanent residence. I say simply, of course, it's no small feat to have obtained permanent residence. And it applies equally to union citizens as it does to family members. Subsection 3 refers simply to union citizens, that's the first thing, and confirms residence in the host member state for the previous 10 years. It doesn't say it has to be continuous, and obviously it doesn't say anything about family members, so family members would not be entitled to that highest level of protection.
So would a union citizen be entitled to the highest level of protection if they had not resided in the host member state in accordance with the terms of the directive? So in other words, if they hadn't abided by Article 7.
Well, the absence of the use of the words legally is important, and that's why I submit that this provision is concerned purely with residence as opposed to legal or lawful residence or anything of that nature.
Right, so is your submission that in order to acquire the enhanced level of protection, the union citizen does not have to have been complying with the terms of the directive? So in other words, they don't have to be exercising treaty rights, they just have to be living here for 10 years.
Yes, because once you acquire permanent residence, and I think this is common ground between the parties, I'm sure Mr. Malik will jump up if I'm saying anything out of turn, as it were, but once you acquire permanent residence, you do not have to continue to quote-unquote exercise treaty rights.
But you do have to have qualified for permanent residence before you get enhanced protection.
Yes, that's clear from Vomero, etc. So the assumption is that you would have qualified for permanent residence upon exercising treaty rights. Thereafter, there is no obligation on you to continue exercising treaty rights, because one of the benefits of permanent residence is you no longer have to carry on working or studying or whatever it is.
That's in order to carry on living here, but we're talking about something different. So we're not talking about residence, we're talking about protection from expulsion if you commit a crime.
Yes, but it's premised on residence in my submission, because it says has resided for 10 years.
But I thought the authorities showed that you have to test the protection against expulsion by counting backwards from the date of the relevant decision. In other words, it's that you have a right of residence isn't permanent. It's not the same. You have to. I thought at least one of the authorities, and it's probably Vomero, but says you, for the purposes of looking at protection against expulsion, you count backwards from the date of the decision, relevant decision, whatever it is. And so, for example, the fact you may have earlier than 10 years acquired a right of residence doesn't of itself help you. That may not be directly. I'm struggling to figure out whether that's consistent with or flows from your submission or not.
Yes. So my submission is that there has to be residence for a period of 10 years prior to the Secretary of State's decision. I think that much we agree on. That residence does not have to encompass a period where someone is necessarily lawfully resident throughout, because it essentially bakes in the fact that they would have acquired 5 years permanent residency, after which point they no longer have to work or exercise treaty rights, because they've already obtained permanent residency, and that means essentially that's that in terms of whether or not someone has to continue working, etc.
So even someone who's been here unlawfully, illegally, union citizen, can acquire, can only be expelled on imperative grounds.
No. Because, as I've said, it already bakes in the assumption, which is then spelled out in the regulation, that you have obtained permanent residency. So it's inconceivable that someone who's here illegally and unlawfully would ever obtain permanent residency.
Where does it say? Where is so permanent residency is a condition, is it? Of
It is
Article
because-
28.3.
Not of 28.3, but when we read the regulations, Regulation 27, we'll come to that in a moment. When we look at what Vomero says,
Yes, I'm asking about under the directive.
yes, the directive
Is there
does
any
not,
requirement for the presence to be lawful?
the directive doesn't spell that out, but if you read the directive as a whole, it's quite clear that you only get to stage 3 if you met stage 2, which is the permanent residence.
I mean, that's what the Court of Justice said.
Yes, precisely.
Romero.
And that's why I may not be making my submission clearly enough, but when I talk about it being baked in, there's an assumption within Article 28.3 that you would have already obtained permanent residency, and that's what takes you to the next level, as it were. That's a prerequisite.
You look at-
Is that the passage that's quoted?
But if we look at paragraph
Sequence.
26 of the Supreme Court
Yeah, that's-
decision in Romero,
Okay.
their summary of what the Court of Justice decided, I think, answers this question.
Thank you.
If I may then, with the court's permission, take the court to the regulations. I think Mr. Malik has traversed much of it. I'm not going to take up the court's time by going through all of it. But if I can firstly take the court to Regulation 12. And the court will recognize that the Upper Tribunal, when it undertook its analysis of the interpretation of Regulation 27, referred to Regulation 12 and 15, because within those provisions, for example, 12.1a Roman 1, there is specific requirements imposed into that provision. For example, it says the EA national is residing in the UK in accordance with these regulations, which mirrors, although not precisely, the language in Article 16 of the directive, which talks about legally residing. And similarly, page 48 of the authorities bundle, Regulation 15.1a, as well as 1b. An EA national who has resided in the United Kingdom in accordance with these regulations for a continuous period of 5 years, and B relates to the family member. We then look at Regulation 23.9, page 57 of the authorities bundle, and Mr. Malik again took the court to that, and that was in response to the argument raised in the respondent's notice that the claim is academic, because he says decision taken under paragraph 6b or c has the effect of terminating any right to reside otherwise enjoyed by the individual. I emphasize any right to reside. Next, we turn to the provision that we're concerned with today, which is Regulation 27, page 60. The first thing of note is 27.4a, which is the applicable provision, talks about continuous period of 10 years, resided. It doesn't say lawfully resided, it doesn't say in accordance with these regulations or anything of that nature, which is what we see in Regulations 12 and 15, and in Article 16 of the directive. And that we say is an important omission. And it's relevant again to what is said in Regulation 23, subparagraph 9, which talks about any right to reside. A right to reside, in my submission, is different from actual residence. In other words, a person may be here without a right to reside, but it doesn't mean that they're not resident here. So take an example of a person who's illegally here for 20 years, who never had a right to reside. But that is markedly different and distinct from a person who is nonetheless resident in this country, albeit illegally.
Well, under 27.4, there are two conditions. 27.4a, aren't there? There are two conditions.
Has a right to permanent residence, and I'm about to come to that.
And who has resided.
Yes. Now, I'm trying to build up to what I think is the silver bullet in this case. And the silver bullet is this. The language in that regulation, when it says, has a right of permanent residence under Regulation 15, if that provision was only envisaging a circumstance where the union citizen has had to have resided for 10 years, and it only applied to a union citizen who'd been a union citizen for the entirety of the 10 years, then where it says has a right to permanent residence under Regulation 15, that would have been qualified by saying has a right to residence under Regulation 15.1a. Now, I want the court to go back, if I may.
So if they've got a right of permanent residence as a family member, that's sufficient.
That counts, because otherwise the drafter of that provision would have excluded 15.1b by either saying 15.1b doesn't apply, or by saying the right to reside in the permanent residence is only by reference to 15.1a. They haven't done that, and that, in my submission, is a silver bullet, because that provision then envisages a circumstance where a person may have obtained permanent residence as a family member and then gone on to become a union citizen, which is what has occurred in this case.
What could be said against you is that the drafter's assumption might have been the opposite, which is that this is only relevant to a person who's acquired a permanent right to reside as an EEA national because they've been an EEA national throughout.
Well, if it was going to say that, then the simplest thing would have been to say 15.1a applies. They've kept it generic, and I say they've kept it generic for a reason.
Yes, the question is what's the reason why they kept it generic?
The reason is because that 10-year period may include a person who wasn't an EEA citizen for the entirety of the 10-year period, was nonetheless a family member who obtained permanent residence and subsequently became a union citizen. And that is why I say that this...
If we were dealing with the regulation before it was amended, what would your client's position then be? Would your client, in other words, if it wasn't a requirement that the individual has a right of permanent residence, but merely that they resided in the UK, would you be in any different position or not?
No, my lord, because of what the Supreme Court says in Vomero. My Lord Justice Snowden took the court to paragraph 26
yes.
of Vomero, where the Supreme Court grapples with Article 16 and 28.2 of the directive. And the court there doesn't limit its consideration to 16.1, which is in respect of union citizens. It says generically and broadly that Article 16 means that the person has to have had permanent residence, and that doesn't exclude a family member. So the simplest way, as far as my lord, our submissions are concerned, is if Regulation 27.4a was to limit itself to someone who's been a union citizen for the entirety of the 10 years, then the reference to permanent residence under Regulation 15 would have said permanent residence under Regulation 15.1a. And that, in my submission, marries with the other language used. For example, it refers to an EA national. It doesn't say who's been an EA national throughout It doesn't say who's been exercising treaty rights throughout or anything of that nature. And when you compare the language of that to regulations 12 and 15, much like what the Upper Tribunal said, it's quite clear that EEA citizenship isn't linked to the 10-year period. And that takes me back to the recitals in the directive, which speak about the fact that a union citizens, the longer they spend, the stronger their ties are, etc. That union citizenship is relevant to social cohesion, etc., etc. So it is not by accident that the respondent, Mr. Borges, becomes a union citizen and therefore benefits from this. It is very much the intention of these provisions that union citizens who've resided for 10 years, because of their status as a union citizen, deserve a higher level of protection. Ultimately, this whole regime was created to facilitate the entry of union citizens,
Well, no, not just their entry.
their residence, their
The
expulsion.
purpose of the directive is to encourage the exercise of rights of free movement.
Precisely.
So it's not just to facilitate people's entry, because if that were right, the provisions would be very different.
Forgive me for my loose language, but it's
Yeah.
broader than that. But the whole idea is to encourage people to be able to move freely, to work and live in other member states.
Can you just walk me through how these principles apply to a family member? As I understand it, if we would go back to 15 and look at 15.1b, I'm just trying to think through your point about that 27.4a doesn't refer to 15.1b, it just refers to 15 generically. Sorry, it isn't limited to 15.1a, I think is your point, sorry.
Yes.
So you have a family, so you have a family member of an EEA national who is not an EEA national.
They can never benefit from imperative grounds.
Well, okay, but yeah, so let's say you have two EEA nationals.
Yes.
Sorry, no, that makes it rather more difficult. So one EEA national, one non-EEA national. They have a child who lives with them in the UK. So there will be somebody that child will fall within the definition of 15.1b. They will be a family member of an EEA national.
But they may not be. They may be a union citizen in their own right.
Let's assume they're not. Sorry, let me assume they're not. I'm trying to fit within 15.1b. So, family member of an EEA national who is not an EEA national. So the child has not got the nationality of the EEA parent.
Yes.
Okay, let us assume it's got the nationality of the
Non-EEA.
non-EEA parent. It could be, for example, an EEA father, let's say, who starts work here, and then his non-EEA wife and young child join him here. So that family member will get a right of permanent residence after 5 years, continuous residence here. When do we then see paragraph 27.4a kicking in relation to them?
If subsequently they take on EEA citizenship. If they don't,
Yep.
then they're excluded by the opening words
Right.
of
So,
EEA national.
and so how many years, so let's assume that at some point after getting the right of permanent residence, after 5 years, they become an EEA citizen because they get the passport of their father.
Yes.
And they're applying it as his child. At what stage does their right under 27.4a kick in? Do you count the 5 years when they were living as a non-EEA national with the father or not? You'd
would,
say you would.
because it just talks about a 10-year period within which obviously you would have obtained your permanent residency. It doesn't matter which category you've obtained it in, as long as you have permanent residency. But the key question is, at the date of the decision taken by the Secretary of State, are you a Union citizen or an EA national? And that may be, for example, a day prior to her decision you obtain citizenship, or it could be 30 years prior to it.
Right, now the case against you, I think I understand it, is that you only count the 10 years if prior to the 10 years, sorry, if during the 10 years at all time, day one starts when you get your EEA passport.
Yes, I say that's contrary to the clear language.
Right.
Because otherwise it would have said you would have had to got permanent residence under 15.1a, or it would have said you've resided for a 10-year period as an EA national throughout, or exercising treaty rights, or something to that effect.
What's the policy reason to support your submission that that person could be a child, or something, a child, a minor who obtained the changed majority during the period?
Well, there are a number of
What's the policy that underlines the protection kicking in sooner rather than later in your case?
The policy reason is firstly that taking the example of a child, the child may not have a say in when they can apply for that citizenship. So then what happens is you penalize a child for actions or inactions by adults, as it were. The second thing is that if the Secretary of State's construction is right, you would have, at the end of the day, 2 Union citizens who are being treated unequally. So there'll be 2 tiers of Union citizens, one who spent 10 years and therefore qualifies for that, but another who hasn't spent 10 years as a Union citizen, who's now being treated not as a Union citizen because they haven't spent 10 years.
Yeah, and the first reason is that you say it shouldn't, the protection shouldn't, or for somebody who is an EEA national, shouldn't depend upon the happenstance of when their parent decided to get an EEA passport from them.
And Mr. Malik stated an argument, talks about the fact that the respondent, Mr. Borges, took on this EEA citizenship. We know that citizenship isn't something that, it's not like applying for a TV license, it's given to you like that. You have to qualify, and that is why when you look at the total scheme between the recitals, the fact that you're a Union citizen is a significant factor. It doesn't happen just by chance, and therefore it needs to be given that added level of protection. But from a policy perspective, you have the situation where a child could have applied earlier, but parents didn't for various reasons, or you have the 2-tier Union citizens, 2 classes of Union citizens, which clearly is contrary to the scheme itself because it only talks about 3 categories of people: Union citizens, family members, and other or extended family members. And whilst we're on the regulations, just to respond to a point Mr. Malik raised earlier on about the academicness or otherwise of this ground. If the court can look at Regulation 32, page 64 of the authority. I think Mr. Malik's argument was, well, the 10-year period talks about that period going backwards from the date of decision, and therefore, even though the respondent has accrued 10 years now, that's irrelevant because the 10-year period counts backwards. What 32.5 says, that where a deportation order is made against a person, the person is removed under the order during the...
I've missed the wrong. You're 32.5 of the regulations.
Yes, authority bundle, page 64.
Sorry, 32, which paragraph?
Subsection 5, my lord.
Yes.
It talks about the fact that if a deportation order is made, but removal doesn't take place in a period of 2 years, then at the end of those 2 years, the Secretary of State has to review, essentially, to assess whether there are any material changes in circumstances. Now, taking the facts of this case, Secretary of State, under that provision, and by extension the tribunal in its capacity as a full merits-based assessor of facts, would have to consider whether there has been a material change in circumstances, and that, in my submission, would be the fact that he's now completed 10 years, even on the Secretary of State's construction.
Well, that only applies if the Secretary of State wants to take action to remove the person after a 2-year delay.
Yes, so there's already been an order in this case in 2022.
Yeah.
More than 2 years have passed. The whole purpose of this appeal is that the Secretary of State wishes to remove the appellant,
Yeah.
remove Mr. Borges. So when the tribunal comes to assess that question, it will have to have regard to this provision, which then doesn't limit the consideration of Regulation 27.4, even on the Secretary of State's construction, to the 10-year period prior to the decision.
So I'm sure it's my fault. I'm just not following this submission at all. So when the tribunal assesses what question?
Question of removability or deportation.
Right.
So when it's looking at is it proportionate and lawful to deport Mr. Borges, which is what the respondent is, which is what the Secretary of State is asking the First Tier Tribunal and the Upper Tribunal to do.
Yeah.
It will have regard to this provision, which says that if a 2-year period has elapsed from the date on which the order is made, in this case the order was made in November 2022,
Yeah.
then the Secretary of State may only take action to remove if, having assessed whether there has been any material change in circumstances since the deportation order was made.
Well, so that means things like he's had his say, assume it's a man and he's got a partner or wife, they've had a baby, he's undergone courses to rehabilitate him, all the rest of it. That's what that's directed at, isn't it?
Yes, it
Make
includes
sure
that.
the Secretary of State doesn't remove somebody if there's been a 2-year delay without considering afresh the question of whether there are grounds of public policy, public security or public health. I don't understand how this helps you on the respondent's notice.
It helps me because what the Secretary of State is arguing is that the 10-year period stops at the date of decision and that's it.
But there are various provisions that say that.
Yes, but this provision says the opposite in a sense. So these provisions can't be looked at in isolation. This provision says that if a 2-year period has passed, then there has to be a consideration of whether there's been any material change in circumstances.
Yes.
Now, the material change in circumstances would be the fact that as at the review point, after the passing of the 2 years, the Secretary of State would have to then look at whether this applicant now qualifies under Regulation 27.4, applying her own construction. That would be a significant material change in circumstances, i.e. that he now meets the provision.
But he can't meet the provision because the clock stops effectively when the relevant decision is made. That's what I'm not understanding. I don't understand how this provision overrides the other provisions, that's the effect of which is that the clock stops when the deportation decision is made.
I say the clock is paused at that point, but if a 2-year period passes, then the Secretary of State is under an obligation to review the position, including looking at whether there are material changes in circumstances. That's the first thing I would say. The second thing I would say is that the regulation itself talks, for example, at 27.5 A and C, in the present tense and with respect to present matters such as proportionality and whether the conduct of the person represents a genuine present and sufficiently serious threat. The point I'm making, perhaps not very well, is that when it comes to that assessment, it's difficult to see how a tribunal could conclude that a person who now meets 27.4A, because they've clocked up the 10 years at the date of the appeal hearing.
Well, it's because it's an appeal against an EEA decision, and the EEA decision is taken at the time when the EEA decision is taken, on the facts as they were at the date of that decision.
Yes, but it's with reference to circumstances at the present time.
Could you just remind me of the provision which freezes the time as it date of the decision?
27.4a talks about continuous period of at least 10 years prior to the relevant decision. I think what perhaps I should clarify is an appeal to the First Tier Tribunal isn't a review. It isn't, for example, in the Begum territory where it's limited to public law principles.
Yes.
It is a full merits-based assessment, and the respondent the Secretary of State accepts that because she criticizes the First Tier Tribunal for not undertaking the proportionality assessment, the consideration of whether the individual presents a genuine and present threat. So clearly, the tribunal is looking at things as at the date of the hearing.
How can 32.4 32.5 I think you may have already, Milady's already asked this question, but if the trigger point is the relevant decision can't be taken except on imperative grounds, where the person has resided for a continuous period of at least 10 years prior to the decision, how can that trigger date be changed? How does 32.5 change that triggering date?
Because in my respectful submission, my lord, there's an obligation on the Secretary of State, if a period of 2 years has passed, to reevaluate, reassess the circumstances relating to the applicant, including whether there are any material changes in his circumstances. So at that point, there would either be a new decision or a supplementary decision.
So in other words, it's a different decision under 27.1.
Yes. But it would then have to have regard at that point to whether or not the provisions are met or not.
But that's a problem, isn't it? Because so you have decision to deport, you have then a period of time. You say there has to be a new assessment.
Yes.
But at the point, that second point in time, you wouldn't have the 27.4a protection at all, because if the later, I'm not sure. Sorry, I'm happy to. I mean, the later decision is not a relevant decision for 27.4a purposes.
Why would it not be, my lord?
Well, if it is, you haven't got a continuous period for at least 10 years prior to it, because the continuity of residence is broken when there's an exclusion or a deportation order.
3.3b.
Yes, I respectfully disagree. The continuity of residence is not broken when a deportation order is made. The right to reside is broken, which is different to residence per se.
But the continuity of that residence is broken by the deportation order. See Regulation 3.3b. So if there's a break in continuity, you can't surely add on periods that occur after the decision to deport.
That's what I was trying to say. Either the relevant decision is the first decision, in which case 32.5 doesn't help you any. And if the relevant decision is the decision taken on review under 32.5, you don't have enhanced protection anyway, because the continuous period of residence referred to in 27.4a stopped when the first deportation order was made, surely, because of 3.3b.
My response simply would be that once the second decision is taken, it subsumes and overtakes the first decision, and therefore that period would count.
You're saying it's a new order then?
Yes,
Well,
precisely.
it may be a new order, but you haven't got a continuous period of 10 years prior to if prior to means ending on the date of the relevant decision, which I think it does, according to
Yes, I mean, I can only make that point.
Even if it's a new order, Mr. Karim, there's still been a break of the continuity because a deportation order was made in the first place.
Yes. My submission would be that once the second review decision is taken, it essentially will lift the first one because there'll be a second decision and therefore that period would count.
In any event, the removal under 32.5 is not a fresh removal, but it's a removal under the order. The Secretary may only take action to remove the person under the order. So there's no suggestion that the order is
Anything other than
set aside. The original order is set aside. It's just that before the Secretary of State can take action to remove under the order, she has to consider the material change in circumstances.
There may be one authority.
But I'm sorry, I interrupted
Not at
you.
all, my lord.
I mean, I think this is quite a difficult point, and it's not one I anticipated. So,
But I mean, even if 32.5 doesn't help you, I mean, I understand, I think the argument you made, but none of this affects the previous arguments.
No,
No.
not at all. This is completely
This is just your respondent's notice type one.
precisely, yes. This
So-
is an
so-
additional
For my part, I
point
don't think
segregated from my primary.
to be frank about it, the moment where I am is that you're not persuading me on the respondent's notice point, but your
Right.
first point seems to me to be have more substance. Whether it's right or not, I don't know.
I'm grateful, my lord. I don't propose to make any more submissions on this point about.
Well,
mixing.
can we just go back to your first point, because it's just trying to think if there is a policy or principle reason behind it. This would explain the family member. You could argue, I'm giving you a point here, I'm not saying I'm with you, but I'm just thinking about pros and arguments for and against. This adds a degree of protection to family members, which is otherwise arguably lacking in the structure of the directive and the regulation.
And you say your interpretation avoids entirely inopportune or unfortunate differences between family members, especially young family members who become adults, whose rights are otherwise entirely dependent upon the happenstance of as and when their parents acquired
Precisely.
EU citizenship for them, which was not under their control, but would lead to very different results for them.
Precisely.
And on the one hand, somebody could say, well, that's just tough. I mean, that's the way that the system, there's always tough cases in the system. But you say that that's not what the recitals indicate is the purpose of this, which is to foster, what was it?
Cohesion.
Cohesive social cohesion between people who, on this hypothesis, are union citizens at the time you begin to ask the question.
Precisely.
When you ask the question.
Yeah, falls within the recitals, the purpose of the directive in the recital.
Yes, and the example of it being a tough case applies both ways. It may well be that this is a tough case for the Secretary of State as well, who wishes to deport a union citizen for various reasons, but because he's a union citizen and has resided for 10 years, albeit not for the 10 years as a union citizen, he benefits from this. And those types of tough cases can fall either way. But I say that my interpretation is the one which is more in tune with the recital, with the directive, with the scheme.
But in paragraphs 48, are you going to come on to Romero in more detail? Are you going to go back to Romero or not?
Yes, I think Romero, again, it doesn't qualify the permanent residency and limit it only to union citizens for the purposes of this provision. It says Article 16 full stop, which encompasses the entirety of Article 16, much like what the regulation says. It says Regulation 15 full stop, not 15.1a, or doesn't refer to 15.1b being excluded.
Because on the facts of that case, the person, Mr. Romero, was a union citizen throughout. So I think it's difficult to argue that by some form of implication, the Supreme Court have accepted your argument when your argument wasn't before them and they were only dealing with somebody who had been a union citizen
There are
throughout.
two things, my lady. One is that I say that the Supreme Court has accepted the proposition that I'm advancing, but more importantly, when it came to drafting or redrafting Regulation 27.4a, the draftsperson could have limited 27.4a to 15.1a and said it only applies to a union citizen, full stop. So it would be a massive coincidence if the Supreme Court is saying the same thing, which is then reflected in the regulation, which is then what I'm advancing on behalf of Mr. Borges, that when we look at all of this, there is no qualification to that 10-year period by reference to, for example, the person having to be a union citizen for the entirety of that period, or for the permanent residency to have been obtained as a union citizen. And it envisages in my submission the scenario which arises in this case, which is a person may have obtained permanent residence as a family member, subsequently becomes a union citizen, and at the date of the expulsion decision, if they are a union citizen who's resided for 10 years previously in various capacities.
Yes. So this morning you enigmatically said that this is an unusual set of circumstances.
Yes.
My word, enigmatically. And this would be quite an unusual set of circumstances. This is someone who's come to this country as a child of a union citizen, but not themselves a union citizen. One imagines that most children of, I don't know, many children of union citizens will have their own passports and nationality of that country. Then they acquire the right, permanent residence, as a family member, and then subsequently acquire the citizenship of the original country.
Yes.
And then their position has to be interpreted under the regulations. So that is quite a narrow group of people.
It is a narrow group, but
No? The law's not persuaded.
Two that I know.
What?
Possibly. Anyway.
Okay, well, I mean...
But
Can I just put 2 points to you so that you can see what you say about them, please, Mr. Curran? The first point is that it could be said against you that this point was so obvious it didn't require to be spelt out. What would you say to that?
my lady, what I would say is that it clearly isn't so obvious because there are 2 specialist tribunal decisions which support my proposition. So that's
All right. So that's your okay.
Maybe in your advocacy, Mr. Curran.
2 decisions support it. Second question is, are you submitting that the Supreme Court has decided this point in your favour without mentioning it? Is that
I'm
your
not
submission?
suggesting that. I'm saying that the Supreme Court has used Article 16 generically, and that's then reflected in the regulation itself without any qualification.
Yes, but the similar argument might be said to apply to the decision of the Supreme Court, which is that they were only dealing with the situation of a person who had been a citizen of an EU country throughout, and that's all they were deciding.
Yes, that may well be the case, but that doesn't then reflect on why the drafter of Regulation 27.4a has taken the same approach. Because if it was such an obvious point, they would have inserted in there something like this is excluded to 15.1a cases.
Well, no, that goes back to the first point. It's so obvious it doesn't need to be said. But anyway, I've got
clearly
your
isn't so
submission.
obvious because in my submission there are competing arguments on both sides. We don't have any specific authority, and we can only go by what the clear language of the provision says. And the Secretary of State criticizes the Upper Tribunal for essentially inserting words that are not there.
Yeah.
I'm trying to do the opposite. I'm saying let's not insert anything into this. Let's not assume anything, and let's look at the plain language of this provision. Let's look at what the intention is behind the recitals and the directive, what policy intentions there may or may not be. And as my Lord Justice Snowden has rightly pointed out, a child who is otherwise not in control of their affairs may not have the power or the ability to make an application for citizenship, would then fall foul of it because this provision is being interpreted the way the
Yeah, and I was going to put, again, perhaps I can just pick it up and finish my thought on that. I mean, as I understand it, a point that's been made against you, I think, or at least made to you for your comment, flows from what the European Court of Justice said in its judgment of paragraphs 48 and 49, which you can see, it's in the bundle, the authorities bundle at page 136, for example, just picked up earlier this afternoon, where they talk about the structure of the directive and the protection against expulsion gradually increases in proportion to the degree of integration of the union citizen concerned. I think the point was made, well, that could be taken to mean you only begin to, as it were, accumulate your protection as you are a union citizen. That's the argument I think that is made against
What paragraph?
48 at page 136 of the authorities bundle.
Also quoted in
It's quoted in the
the
Supreme Court.
Supreme
back
Court
again.
decision that we've
my
been
response, my lord, to that.
Sorry, I haven't quite finished the point in your favour, so don't, as it were, stop you just at the moment. Because I wondered whether your point was, if you go then to recital 24, because it's if you paragraph 48 talked about the gradual increase in proportion to the degree of integration. So we're talking about integration. So recital 24 at page 5 is where it says the greater the degree of integration of union citizens and their family members, the greater degree of protection. And only in exceptional circumstances, etc., should an expulsion be expulsion measure be taken against union citizens who resided for many years in the territory of the host member state, in particular when they were born and have resided there throughout their life. I think the point I was trying to put to you earlier is that you could have two union citizens, both of whom were born and have resided in a member state throughout their life. But the Secretary of State interpretation would lead to could lead to the conclusion that one of them would have protection and the other would not, simply upon the happenstance of when an application had been made for EU citizenship, even though in terms of integration and specifically in terms of when they were born and resided throughout their life, they're in exactly the same position.
Precisely.
They were both born in that state, they resided throughout their life. But you'd say, I think, the same result would necessarily apply to them both, provided that they were over 10. Whereas the Secretary of State would say no.
Yes.
The clock starts running at a different point of time for them both, even though integration terms they're in exactly the same place.
Precisely, my lord, and that is why I spoke earlier about the Secretary of State's interpretation creating two classes of union citizens, which is clearly not.
I mean, there are plainly different groups of EU citizens who have different rights of residence at various different times of their
residence.
We know that there's an increasing level of protection.
Precisely.
But your point is that's not the point you're making. You're saying in this context you have a regime which doesn't treat people equally.
That's right.
Yeah. Okay. Well, I get the point. I don't agree with it, but I certainly get the point, and I'll see what Mr. Malik says in response to it.
I think there was the Romero point, which forgive me, I think the court raised an ancillary point about Romero and paragraphs 48.
Mulaney referred to 48. Did you? Somebody referred to 48.
That is 48. That's the one I've just been.
That's
paragraph
what they've just
48
been talking about.
Yes.
That's exactly the point I was
Yes.
trying to pick up my lady's point from earlier. I think if my lady could put that to you.
Yes, and the other point that I wanted to make in respect of that is that even within the directive and the regulation, those who are family members are given an increased level of protection as well, to a certain extent. So that recognises that the longer you spend, the stronger your ties are, and more is needed to deport you, essentially, to an extent, of course. The ultimate third tier, the imperative grounds, wouldn't apply to the family member. My lady, my lords, I think that's all I have to say on ground one, unless there are any particular questions. What I propose to do is then take the court to ground two. And if I can do that, perhaps, firstly by reference to the underlying decision, that's the Secretary of State's decision. And that's in the core bundle.
Starts at page 108.
I did touch upon earlier the fact that there is no definition of what amounts to imperative grounds. That's spelled out in the Secretary of State's guidance, which the Upper Tribunal refers to. I can take the court to that at this stage, or I can take it at a subsequent point. We turn to the decision behind tab 14. What we see, paragraphs 31 onwards, is the Secretary of State making a primary point, which is the point advanced before this court as ground one. And quite unusually, at paragraph 37, rather than adopting a belts and braces approach, the Secretary of State says consideration has not been given to whether your deportation is justified on imperative grounds of public security. And that, in my submission, is quite remarkable, particularly when imperative grounds is not defined.
But why is it quite remarkable if the Secretary of State was confident that the enhanced level of protection didn't apply?
As I said, a belts and braces approach should have been taken, but that's the first opportunity where she could have said, nonetheless, alternatively, as we see in most of these decisions, even in the context of human rights decisions, Secretary of State says, well, we don't believe you meet this provision, but even if you did for X, Y, and Z reasons, we still would refuse your application.
Yes, but she didn't.
She didn't do that in this case. We then turn to the skeleton argument that Mr. Borges presented as part of the First Tier Tribunal. Now, once a decision is taken, an appeal is lodged, there is a system in place post-COVID where skeleton arguments and bundles have to be uploaded well in advance of the hearing so that the Secretary of State can take a view of the matters and review the decision. The skeleton argument is to be found in the supplementary bundle behind tab 6.
I have tabs. I think it's page 39.
That's right, my lord, yes, page 39. And for present purposes, if I can draw the court's attention to paragraph 15 on page 42. So the skeleton argument says, paragraph 15, that appellant qualifies for enhanced protection based on 10 years, and therefore his deportation can only, should say, be on imperative grounds. Paragraph 26 of the same skeleton, page 49. It's spelled out quite clearly that the respondent has not offered any imperative grounds. And then it goes on in the alternative to say that even if the respondent has offered these, it is submitted that in this case that high threshold for expulsion, deportation is not met due to the following reasons. So this is the alternative stance taken by Mr. Borges. So by now, the writing's on the wall. It's clear that the appellant, as he then was, Mr. Borges, is specifically highlighting to the Secretary of State and to the tribunal that you haven't offered any imperative grounds. The Secretary of State has a further opportunity, that's the review, which comes after the skeleton argument. And that review is to be found on page 139 of the supplementary bundle behind tab 13. And paragraph 2 of the review, it expressly says it takes into account the appellant's skeleton argument. So this isn't a case where the Secretary of State can say, well, actually, the skeleton argument wasn't before the reviewer, or we must have missed it, or anything of that nature. And what does she say? What she says in her counter schedule, paragraph 6, page 141, is that the respondent directs the tribunal to the refusal notice at paragraphs 31 to 32, where the respondent does not accept the appellant qualifies for enhanced protection. She chooses not to engage with the point made in the skeleton argument of Mr. Borges that you haven't offered any imperative grounds. We then turn to the First Tier Tribunal's determination. And that, I believe, is in the core bundle. Behind tab 12, page 95.
Sorry, can you give me that reference again? Core.
Page 96 of the core bundle behind tab 12.
32, paragraph 32. Do we go to?
Yes,
And 33.
yes. And this ties in with the point which I made at the outset, that these are specialist tribunals, but they're not clairvoyants. There are a number of issues which arise from the approach which Mr. Malik invites this court to take. Firstly, imperative grounds are not defined, so the tribunal can't pluck out of thin air what it might assume to be imperative grounds. The Secretary of State has to present those imperative grounds of public security.
Was there any further argument about this?
There wasn't. There was no submissions made by the Secretary of State orally at the hearing, as recorded at paragraph 32. And the Secretary of State has never taken any issue with what is stated at paragraph 32. The second thing is,
Well, we've seen what's said in the refusal letter, which is that the reason why the Secretary of State didn't put any grounds forward was because of her interpretation of the legal position.
she took a, if I can use the word, rather stubborn position in that regard. Now, I don't mean that in a disrespectful way, but once she took that position, she can't then criticize the tribunal for not, of its own motion, assessing or considering what the imperative grounds may be.
Well,
What does a tribunal do?
can
in those
I just
circumstances?
be clear about this? At the hearing, I can't remember. Were you at the hearing, Mr. Kerrigan?
I was, my lord.
At the hearing, because do I understand you to be saying that there was no submission about this at all?
There were no imperative grounds offered. The Secretary of State's position remained that imperative grounds did not apply because of her construction.
All right. So that's what we okay, that's what
The Secretary of State
the
could have-
tribunal was saying, then, was it?
Yes.
Did the First Tier Tribunal say, well, just suppose, Secretary of State, you're wrong?
I can't recall that, my lord, I'm afraid. I can't recall that, and it wouldn't be fair of me to
I mean, read by itself, 32 could be read to mean that the Secretary of State implicitly accepted there weren't any imperative grounds, or the grounds weren't imperative. But that isn't obviously her position.
Well, 32 says that the respondent has not put forward any imperative grounds for the deportation within either refusal letter or oral submissions at the hearing. That means what it says, that the Secretary of State did not put forward any imperative grounds. Mr. Malik doesn't seek to depart from that. He doesn't say, for example, well, there's a mistake of fact because we did actually put forward.
But I don't understand how. I mean, that may all be true, but how does that get round the clear language of Regulation 27A?
Well, we don't even get that far, my lady. What are you balancing against? The absence of imperative grounds versus the applicant's rights. Where does one, to balance, you need to have something on the other side, and there's nothing on the other side, with respect.
What are your submissions about paragraph 33
Sorry.
of the decision? Sorry. Sorry. Just
That's-
a moment. Lady wants to follow up on
Well, I just.
27.
What do you mean there's nothing to balance against it? There are all the factors that are described in the decision letter. Whether or not the label imperative grounds is given to those factors.
Well, if there are no imperative grounds, I think it's difficult to see what balancing assessment is undertaken. Otherwise,
Where are you getting this idea about a balancing assessment?
proportionality.
Yeah, but 27 tells us about decisions taken on grounds of public policy, public security and public health, and how those decisions must be made, and what must be taken into account when those decisions are made. And then paragraph 8 of Regulation 28 says that it imposes a duty on the court or tribunal, when considering whether the requirements of this regulation are met, to have regard to the considerations listed in Schedule 1. So whether or not the Secretary of State puts forward imperative grounds, at the moment I'm just not understanding how it is that the FTT is not itself required to look at the considerations in Schedule 1 having regard to the material in the decision letter.
If that approach is correct, my lady, with respect, that would make Regulation 27.4a OTOs, because it means Secretary of State doesn't have to say there's imperative grounds, because 27.8 and Schedule 1 has to be applied in any event. The point I'm making is, for there to be a consideration of 27.5 and Schedule 1, there needs to be something.
I think I see what you're saying. All right.
Because those provisions apply to all levels of deportation. But if there isn't an imperative ground to start with,
Well, if no imperative ground is raised,
yes, then what is the court looking at with respect for the tribunal? Because those provisions would apply equally to someone who's been here for a day as a who's subject to deportation, or with someone who's obtained permanent residence and is subject to mid-tier deportation. The difficulty is that there has to be an imperative ground. And when we look at the Upper Tribunal's determination,
well, just a moment, just take it in stages. So therefore, because the Secretary of State hadn't raised any imperative grounds, is this what you're saying? The FTT did the right thing. The only course open to it was paragraph 33 decision.
yes, 32 and 33, yes, my lord. Because we have to understand that, with respect, the system in this country is an adversarial one. There are opportunities given to both parties to put forward their case, and that is why we have issues and skeleton arguments and schedules of issues to narrow down the focus of the tribunal. If the tribunal has to gallivant and find things which parties haven't put forward, then the adversarial system changes to an inquisitorial.
Why did the FTT therefore say, I find that there are no imperative grounds? I find there are no.
Because none have been advanced.
That's not quite the same thing, is
I mean,
it?
the language may be loose, but one of the things which the Court of Appeal in the case of Volpe says, and that's one of the reasons why I've included it, if I just take the court to it very quickly. This is authorities on law.
Yeah. Well-trodden territory in this cause, folks.
Yes.
So how is Volpe? I mean, we're all pretty familiar with Volpe. It gets cited in this court very, very often. Could you just explain how it's relevant to ground 2?
It's relevant in this respect, lady. We turn to Volpe, paragraph 2 of it. That's
2 is where
241, yes.
paragraph 2 in Volpe.
Roman 6 Reasons for judgment will always be capable of having been better expressed. An appeal court should not subject a judgment to narrow textual analysis, nor should it be picked over or construed as though it was a piece of legislation or contract. And that's why I say that 33 could have been expressed differently, but it's quite clear what the understanding of the intention behind.
Well,
Nothing
what do you say was that intention? You say
I
it's
say
clear.
that was because there is an absence of any imperative grounds advanced by the Secretary.
Because the Secretary of State had not raised any grounds, appeal allowed.
Yes, because the tribunal doesn't know what the imperative grounds of public security are. That's for the Secretary of State to put forward. And that is why I'm coming now to the Upper Tribunal's decision.
With respect, Volpe, which I signed up to as part of the court, was a case which was an appeal on fact. I think I'd actually given permission for it. It was where there had been a full trial or allegations of forged documents, expert evidence on handwriting, various other things, and the judge had essentially, I think, differed from some expert evidence, and so there was undoubtedly, a trial in a real sense where there were factual findings by a judge who'd heard evidence and the like. And in that context, Lord Justice Lewison sort of reiterated the approach of an appellate court. I mean, in our situation here, as I understand it, the Secretary of State said right at the start in the decision letter.
She's not going to offer any imperative grounds.
Well, it didn't. No, I think what actually said at page 115 of the supplemental bundle, as I understand it, paragraph 36 would take a legal view, for better or for worse,
Yes.
and it's no consideration. Consideration has not been given
Yes.
to your deportation, so they just haven't engaged with it at all. When you get in front of the FTT, yes, they did put forward the Secretary of State does not put forward any imperative grounds, any argument that if they were wrong on the law, there were imperative grounds. So, I mean, it's not really akin to a Volpe case, is it? In the sense, because there's just an absence of finding by a tribunal based upon an assessment of evidence and
It's an absence of
evaluation. It's just nothing.
There's an absence of a finding, but one can say that, but there's actually a finding that there are no imperative grounds because none have been offered. And perhaps the situation...
Well, I understand your point about, we have an adversarial system and you get a chance to put forward your case, and the sort of analogy I might think about is if you have a contract dispute and somebody argues an interpretation and then rocks up on appeal and says, oh, actually, if I'm wrong, I still think I'm right on interpretation, but if I'm wrong, I want to argue misrep or frustration or something completely different, to which the court might say, well, you had your chance, tough. But it's not really a Volpe point, is it?
The reason I've taken the court to Volpe is for that last Roman numeral.
Yes,
Paragraph 2, which
so
is
that's part of the. The
It's
Volpe dicta are all part of the overall approach of this court, which is that we don't interfere with findings of fact, except where there's a justification for doing so, for the reasons explained by Lord Justice Lewison in Volpe, and before that in the Phage case, better known. And the reason is that trial judges see the witnesses. They are in the best position to evaluate who is telling the truth, what the factual position is. And this court, we don't do that. We just review. That's the whole. That's the principle, overall principle.
Yes.
That principle doesn't really arise in this case because there was no evidence. There was no point taken. The issue just wasn't raised.
Well, the issue was raised from our part in our skeleton, and I've taken the court to it. So it's not as if this is something which has escaped everybody's mind, and then suddenly we've realised at the end of everything, oh, actually we haven't dealt with this.
Are you saying that the First Tier Tribunal made an evaluation of whether or not there were imperative grounds?
No, I'm not saying that because there were no imperative grounds advanced by the Secretary of
So
State.
what's the significance of the fact that you said there weren't?
No, my lord, what I'm saying is that the First Tier Tribunal was placed in a situation where the Secretary of State, despite being prompted, is the best word I can use in the skeleton, by reference to the fact that no imperative grounds have been advanced by her, chose not to advance any, even at that late stage before the First Tier Tribunal.
Do you
What-
attach any weight to the way it's expressed in paragraph 33 of the decision? Is there a positive finding, are you saying, by the FTT that there are no imperative grounds?
I'm saying whichever way you read that provision, it's favourable for us, because the way I read it is 32 says nothing has been advanced, and therefore I find that there are no imperative grounds. It could either mean there are none because the Secretary of State hasn't advanced any, or having assessed it for myself, I find that there are none.
But if it was the latter, then there's no reason. There's no reason
Yes,
at all.
but
There's no
I-
evaluation of the evidence.
Yes, but my position is that it's the former, because
Yeah, okay.
33 has to be read with
Not
30.
raised, therefore
Yes.
not raised.
And
Okay.
it's a matter of public security, which is really within the Secretary of State's remit. And we have to also understand that the burden of proof in this appeal, when it was before the First Tier Tribunal, is on the Secretary of State. She is the one that's seeking to deport or exclude. She has the burden of proof. And it is somewhat akin to one of the other authorities, the case of Ullah,
Yeah.
which is in the authorities bundle. I needn't trouble the court at this stage, but that was a case where there was an allegation of deception, and the Secretary of State chose not to cross-examine. This is a fortiori, because not only did she think she had three opportunities to advance her case: the refusal decision, the review, or orally before the First Tier Tribunal, and she chose not to do that in any of those occasions.
You want to take us to the Upper Tribunal,
Yes.
do you?
Yes, ma'am. The Upper Tribunal's decision is behind tab 9, page 62.
So do we go to 48, 47, 48?
Yes, just bear with me.
47 and 48 summarise where we've got to, I think, this afternoon.
Yes, so 47, the Upper Tribunal quite rightly confirms that the primary duty of the respondent is to identify the imperative grounds.
Yeah.
52, you'll see the Upper Tribunal refers to the strictness of imperative grounds,
Yeah.
and the Secretary of State's guidance is quoted. And the first thing the guidance says is imperative grounds of public security are not defined. So this is unlike, for example, section 117C of the 2002 Act, which says if you've been convicted of a sentence between 12 years and 12 months and 4 years, then this is the applicable legal test. If it's 4 years and above, then this is the applicable test. Imperative grounds are not defined. There's a margin of appreciation given to the state. Imperative grounds of public security requires, in my submission, the Secretary of State to say, well, these are the imperative grounds of public security why we seek to deport this individual. What does a tribunal do in those circumstances? It cannot for itself, in the course of a determination, decide, well, actually, it could be this or it could be that, because then we're into the land of conjecture. Similarly, a core principle of our justice system is the independence of the judiciary. Now, if a judge, who having introduced himself as being impartial and independent of the Home Office, then says, the Secretary of State hasn't raised any imperative grounds, but I'm going to surmise that in this case, the imperative public security point is X, Y, and Z. What does that do to the confidence of an appellant in terms of impartiality? Well, it shatters it in my
But what is the tribunal to do in those circumstances if it thinks there are potentially imperative grounds?
Well, it has to be very much led by the parties, and that is why we have this process in place where once a decision is taken, written document has to be uploaded setting out the appellant's arguments and perspective, the respondent has a chance to review that and put in writing on a second occasion, and then you have the oral hearing itself, where a third occasion, a third bite of the cherry is given for parties to raise matters which were not previously raised. And it has to be led that way. Otherwise, it will be a free-for-all. Judges will be going off on all sorts of tangents, having to do different things which parties haven't done.
So if the tribunal thought it's not been raised by the Secretary of State, but there are potentially imperative grounds here, what happens?
The problem is potentially imperative grounds. How does the tribunal know what those are, given the absence of a definition, given the absence of the Secretary of State putting forward what the public security imperative ground is? Because that is very much within her remit.
What's the answer to my question then?
The answer is the judge does what the judge in this case has done, which is Secretary of State who has the burden hasn't put forward anything. End of story.
Well, that wasn't your submission to the tribunal, was it?
Well, my submission was that no imperative grounds have been advanced.
Well, I read the second sentence of paragraph 50 as being an alternative submission.
Yes. Alternatively, if there are imperative grounds, because at that stage I'm not sure what the Secretary of State will say in her review or at the hearing. And that is why I'm putting the Secretary of State on notice. That's not the final document in these proceedings before the First Tier Tribunal. That is only the first document from the appellant, Mr. Borges.
Well, as I read this paragraph 50, you submitted to the Upper Tribunal, first of all, that if there were no imperative grounds, you were content for the Upper Tribunal to proceed to remake the decision.
Yes.
And secondly, if you were of the view there were potentially imperative grounds, if the tribunal was, your submission was that your client should have the opportunity to address the tribunal.
Yes.
And it
So
should
again,
therefore be remitted.
that's a belts and braces approach, because at that point, even that late in the day, I am trying to, as it were, create wiggle room so that if the Secretary of State at that stage says, well, actually, these are our imperative grounds, I don't want the appellant, Mr. Borges, to be prejudiced or disadvantaged because I haven't asked for a further hearing on that. So I'm trying to cover all bases, as it were, by saying, look, there are no imperative grounds, so you can remake it and allow it on that basis. But if there are potentially imperative grounds, given that the Secretary of State will have the last word as the appellant in those proceedings, then we must be given an opportunity to reply to that. That's the way I'm putting it. But let's see what the Secretary of State argued. But that's perhaps more
Can I just
personal.
ask you about where your submission is reported, Mr. Carey? The way that it's recorded suggests that you were accepting or provisionally accepting that the FTT had erred in law by not considering imperative grounds. Because what's recorded is, if we were to conclude there were no imperative grounds, he was content for us to remake the decision on the appeal. Well, the Upper Tribunal doesn't get anywhere near remaking a decision until it finds an error of law.
Yeah, so this is to do with the remaking, my lady. The
Yes.
position that was advanced was that if there are no imperative grounds, well, that's the end of it. We don't need a further hearing to trouble the appellant or anybody else, because much like the First Tier Tribunal's decision, that will be the end of it.
No, but you're recorded as talking about remaking the decision. Now, my point is, you don't get anywhere near remaking the decision unless and until the Upper Tribunal finds there's been an error of law. So were you implicitly accepting that the FTT had erred in law or might have erred in law?
No, I wasn't, my lady. No.
So why are you talking about remaking the decision?
That's a
at all?
summary. That's a summary of the judge, essentially summarising the position taken. But if you look at the Rule 24, pages 16,
But so that's an inaccurate summary, in other words.
it's not inaccurate because the question of remaking arose, and of course the response to that from Mr. Borges was, well, if there are no imperative grounds, straightforward remaking, the outcome is the same. But if there are potentially imperative grounds, then the appellant, Mr. Borges, has to be given an opportunity to address those. The problem that Mr. Borges faces is that even up until that point, the Secretary of State hadn't placed her cards on the table. It wasn't clear what, if any, imperative grounds of public security were being advanced.
Finished. Can I ask Christian? Can you help us with your submission as recorded in paragraph 51?
Yes.
What were you submitting there?
Paragraph 51, my lord, I wasn't submitting anything.
Well,
It says,
the Upper Tribunal says that they had some difficulty with.
Respondent submission is the Secretary
I
of
think
State.
that's reference to.
Oh, I'm sorry.
I think they mean the respondent in the FTT,
Yes.
i.e. the Secretary
I
of State.
see. I'm sorry. That's my mistake. So that's the Secretary of State.
Yes. And if you look at paragraph 49, Miss Everett, who, as I said, is an experienced senior presenting officer, argued that could decide whether or not there are imperative
Right.
grounds of public security in her view. There would be no need for a further hearing.
Yeah,
The
okay.
respondent relies upon the OASIS report. There is no further evidence that the respondent. So even at that stage, all the Secretary of State is doing is simply relying on an OASIS report, which by that stage was about 2 years out of date. She wasn't saying, well, these are now the imperative grounds which I wish to advance. She was simply saying there's an OASIS report. And that OASIS report, as Mr. Malik said, gave a mixed picture. It said he was low risk in certain respects and medium risk in some respects. And it would come nowhere near, forget about imperative grounds with respect, it would come nowhere near even the mid-tier.
But what both the submissions which are recorded in 49 and 50 seems, the premise of those submissions seems to be that submissions were being made about the position which would arise if the Upper Tribunal held that the FTT had erred in law in not considering the question of imperative grounds. Would you accept that or not?
Well, I think if you look at also paragraph 35, which is a further summary of the submissions.
Sorry, paragraph.
35.
So sorry, it's taking a while to find it.
Page
Yeah.
74, my lady.
Yes, got it now, thank you. Right, so that's just recording a submission by you that firstly that the FTT was correct for the reasons it gave, and then further it records your submissions about imperative grounds. What help do you get from that?
Well, the position advanced was that there were neither imperative grounds, as in there were no imperative grounds.
No, I understand that that's the submission that was being made, but it doesn't really help me with my question about the submissions that are recorded in 49 and 50. And what I was suggesting to you was that the implicit premise of both of those submissions is that what the parties are addressing is the position if the Upper Tribunal found that the FTT had erred in law in not considering the question of imperative grounds.
Well, I think you look at 47, in our view, it was the primary duty of the respondent to identify the imperative grounds. So that's the first thing.
Yes.
50, in response, Mr. Karim said, if we were to conclude that there were no imperative grounds for the appellant, he was content for us to proceed to remake the decision.
Yeah.
However, if
okay.
we were of the view that there were potential imperative grounds, then of course an opportunity has to be given.
Yeah, no, I've read those paragraphs and I've asked you whether or not whether there's an implicit premise in the submissions that are recorded there, and I've got your answer. So
There was no concession by Mr. Borges that the First Tier Tribunal had erred in any respect.
no, not suggesting there was. All right, thank you.
And what the tribunal, what the Upper Tribunal were doing were essentially, again, taking a belts and braces approach, in that they were taking into account what Miss Everett said, which is that they could decide for themselves, and there was no need for a further hearing. And when at 51 they say we have some difficulty with the respondent's submission, that has to be read together with 47. In our view, it was a primary duty of the respondent to identified imperative ground. But what they're doing thereafter is saying that in this case, there are no imperative grounds. It doesn't get anywhere near. It falls well short. So they're not.
Does the decision whether or not there are imperative grounds require an evaluative assessment by the Upper Tribunal?
Whether there are imperative grounds.
Whether there are or aren't imperative grounds, does that decision require an evaluative assessment by the Upper Tribunal?
Well, it may be if some imperative ground is put forward, but the tribunal views that it is actually not an imperative ground. So, for example, in a scenario where someone, let's say, has committed a petty theft, and the Secretary of State says, well, there's an imperative public security issue here because this person poses a threat to society.
Well, that's a de minimis case. All right, let me ask the question again. Excluding a de minimis case, does the question whether or not there are imperative grounds require an evaluative assessment by the tribunal?
It would, even in a non-de minimis case, because ultimately there is some deference given to the Secretary of State, of course, because she has to advance what the public security imperative ground is. But it doesn't mean that the First Tier Tribunal is bound by that conclusion if, for example, it concludes that that ground advanced is irrational. Or it simply doesn't get to the imperative grounds threshold. The First Tier Tribunal isn't bound to simply fall back and accept what the Secretary of State says about the imperative ground, but that would be the starting point. And recognizing that she has the expertise of what public security is, much like what national security would be in the context of deprivation.
So,
and the examples given in the guidance, a tribunal will be well within reason to say, well, yes, I recognize that this is non-exhaustive, but it doesn't come anywhere near the types of examples given in the guidance, and therefore I find that it doesn't amount to an imperative ground, full stop.
Right, but does that decision involve an evaluative assessment by the tribunal?
Yes, it does, because they have to
Right,
evaluate.
thank
Forgive me.
you.
Yes, they have to evaluate whether it is in fact an imperative ground issue or not, as it were.
and in this case, what happened was Miss Everett, on behalf of the Secretary of State, submitted that the Upper Tribunal, if it concluded that the judge had been right about enhanced protection, the Upper Tribunal could decide whether or not imperative grounds existed. She didn't ask for a further hearing. She was content to rely on the OASIS report.
Yes.
And when it says there is no further evidence that the respondent would rely on, the last sentence of 49, is that a summary of a concession made by Miss Everett?
Well, I don't want to accept or decline concessions, but it is what it is. Miss Everett didn't rely on, the Secretary of State hasn't produced any further evidence, either at that time or now, that she wishes to rely on.
But are you suggesting that Miss Everett conceded that the Upper Tribunal could go on and decide the imperative grounds question for itself without deciding whether or not the FTT had erred in law?
Well, I can't go behind what is said in paragraph 49.
Right.
If we concluded that the judge was correct to find the appellant was entitled.
I've read it. You're not helping me by reading it out again, Mr.
But
Carey.
it does, what it says is that if we concluded that the judge was correct to find,
I think what you might be being asked is, well, it certainly would help me, is you were there.
I was, my lord, but it was such a long time ago, I can't recall precisely what
Okay.
happened.
Right, so
And I don't want to mislead the court
no,
because
that's fine. I understand then that Miss Everett is recorded as having said that if she was wrong, her arguments were wrong, so I'm paraphrasing here, that if, in other words, if we concluded the judge was correct to find that the appellant was entitled to enhanced protection, in other words, if Miss Everett's arguments in front of the Upper Tribunal failed, that the Upper Tribunal could go on to decide whether there were not imperative grounds of public security existed, and she wasn't asking for it to be remitted somewhere, and you're just saying, I can't remember whether that's actually
Yes,
what happened. It's a long time ago.
That stance
Right.
seems to be what the Secretary of State says is that the First Tier Tribunal, even in the absence of any imperative grounds, should have undertaken an assessment.
I think the point is, you're being asked is, if the Upper Tribunal didn't think that there was any error of law in what the First Tier Tribunal had done, in other words, that there was no error of law and imperative grounds were required, that the Secretary of State said to the Upper Tribunal, well, you can have a look at that yourself. You can, notwithstanding that there's no error of law in what the First Tier Tribunal have done, you, the Upper Tribunal, can take on some assessment, evaluative decision about whether there were imperative grounds.
Yes.
And I think that's what my lady was asking you.
Yes, I mean, that's what I'm trying to understand. Is that what she was submitting, or was she submitting? If the Upper Tribunal found that there was an error of law, well, then she was content for the Upper Tribunal to remake the decision on the basis of material that was before the Upper Tribunal.
I think I can't comment on what exactly happened here because it's too long ago and I can't recall. What I can say is this, my lord, my lady, is the Secretary of State today argues and criticises the First Tier Tribunal for not embarking upon its own assessment of imperative grounds. Miss Everett invited the Upper Tribunal to do exactly that.
Yes.
Now she's criticising the Upper Tribunal for doing what she criticised the First Tier Tribunal for not doing. And that is the inconsistency in all of this. I don't know if that's clear, but
no, it really isn't, because you haven't grappled with the question I'm asking, and quite fairly, because you say you can't remember. But it's one thing to say you, the Upper Tribunal, can make this decision on the basis of the material that's in front of you if you find that the FTT has erred in law. But it's quite different to say you, the Upper Tribunal, can make this decision in any event. Do you see the point I'm making?
Yes, I do, my lady. But what Miss Everett seems to be saying there is that the Upper Tribunal could decide for itself whether or not imperative grounds of public security existed.
Yes.
Which is precisely the difficulty that the First Tier found itself in, because there were no public grounds of public security advanced, imperative grounds. The First Tier Tribunal said, well, there are none advanced, and therefore that's the end of the matter. When it comes before the Upper Tribunal, the Secretary of State doesn't positively assert as the appealing party that these are the public security grounds. I want you to take them into account and determine or undertake an evaluative assessment. What is recorded there is that she's simply saying, well, if you think there is one, you can remake it yourself.
No, she does say more than, sorry.
Yes, I think you may be at sort of I know you say you've understood what the lady's question to you is. I think you may be, in fact, passing like ships in the night here if I'm misunderstanding
That's
this.
my fault for not putting
No,
something.
it's my fault.
I think my lady is saying to you that under the Tribunal Tribunal and Courts and Enforcement Act, it said there's a trigger before the Upper Tribunal can do something, remake a decision, which is it has to find there was an error of law.
Firstly, it has to find that there was a material error of law. What I'm submitting is that this exercise at paragraph 51 onwards is essentially an assessment of whether or not there is a material error of law.
Well, before you get to that, is the material area of law. The question is, was the FTT wrong to reach a conclusion that your client was entitled to enhanced protection? That was the first question. And the Upper Tribunal concluded that it was not wrong, so there had not been an error of law.
Yes, on that ground. But this
Yes.
is dealing with ground 2, which is the Secretary says alternative ground, that even if imperative grounds apply, the First Tier Tribunal was required to grapple for itself with what those imperative grounds were and to undertake an assessment. And here, in respect of that ground, what the Upper Tribunal is doing is saying, well, we have some difficulties with the Secretary of State's primary submission, which is that the tribunal should embark upon an assessment for itself, but having embarked upon the assessment for ourselves, essentially in accordance with what Ms. Everett has said, we find that there are no imperative grounds. So any error, even if there was one, would not be material.
Just rephrasing that slightly. On the second ground, the tribunal says, paragraph 51, we have some, what the Secretary of State was saying was that the FTT erred in law because it failed to consider whether there are imperative grounds of public security. We have some difficulty with that because we never raised.
Yeah, we think that's a bit cheeky.
Yes.
To put it in slightly less judicial language.
Yes.
It's a bit rich. It's a bit cheeky for the Secretary of State to do that in circumstances where they didn't put forward those grounds in front of the First Tier Tribunal. But we can cut through this because we don't need to worry about that because we can just look at it ourselves and decide that there aren't any anyway.
Yes, and that's
that's the exercise I think which troubles my lady.
Yeah, because they expressly say we find it unnecessary to decide. I think there's a whether in this one, whether the FTT might nonetheless have erred in law. So in other words, they expressly say we are not deciding whether or not the FTT erred in law, aren't they?
they're saying it because they've undertaken the materiality assessment. And then when we look at the conclusion, 57, they say, the reasons we consider that the FTT was correct to hold that the appellant could only be deported on imperative grounds, and that no such grounds have been shown to exist.
Yeah, but there's a gap, because the error of law, they just don't decide whether or not the FTT erred in law in failing to decide the imperative grounds question, but simply asserting that there were none. So they don't grapple with that.
What I think they've done is they've taken, for want of a better phrase, a belts and braces approach. They've looked at it alternatively as per how the Secretary of State has advanced her case and said, we don't find that there are any imperative grounds. And then that's why they say at the end of it, the decision of the first tier did not involve an error on a point of law sufficient to require it to be set aside, and the decision stands.
So where are you reading from now?
This is page 84.
Well, that's not even a correct. It's not even a correct test. A sufficient error of law.
One would have maybe substituted that for a material error of law. And that approach, in my submission, is not unconventional, because even this court, this is Authorities Bundle 170. In fact, it starts at 144, FV Italy.
Isn't FV it? Is that a different FV Italy?
No,
It's the same.
It's the same.
It's the same chap.
This is Vomera before this court.
That's right, yes.
Yes.
So where do you want us to look?
Yes, it's paragraph 97 to 99. And in 98, this court essentially is doing what the Upper Tribunal did. It undertakes that type of assessment. It says, I see no real prospect of the tribunal finding imperative grounds of public security to justify deportation. FV has committed a serious offence of violence, justifying a sentence of 8 years imprisonment, notwithstanding those offences and the discretion permitted to a member state. The guidance in Sakuridis, if I pronounce that correctly, probably find that imperative grounds of public security justify deportation. So what this court is doing in that is to undertake an assessment, an evaluative one, and say, well, this case comes nowhere near imperative grounds. And that's precisely what the Upper Tribunal does, looking at matters in the alternative, as it were. and pursuant to what Miss Everett had argued, which is for the upper tribunal to determine for itself whether or not there were imperative grounds.
But this is this court expressing a view in the light of decisions made by the 2008 tribunal, and so this is premised on decisions by tribunals in 2008 and 2008. So isn't it just a summary of the factors that were found by the tribunals, and this court saying there's no error of law in those findings?
Yes, but it starts by saying, I see no real prospect of the tribunal finding imperative grounds, which is what the upper tribunal does when it's looking at this question. It's saying, essentially, we've undertaken the evaluative assessment and we find that no imperative grounds exist, and therefore we can't really criticize the first tier tribunal.
Yeah, well, without reading the whole reasoning, it's a bit difficult to get much from this passage in isolation.
Going back to paragraph 51 of the judgment, what the Upper Tribunal said, as we've explored probably ad nauseam now, we find it unnecessary to decide the FTT might nonetheless have erred in law by not considering the issue, because we find no such grounds to exist.
Yes.
What they should have said, perhaps, was we reject the submission in the circumstances that the FTT erred in law. And if we're wrong about that, at the invitation of the parties, we consider the issue afresh, because application secretary, and we decide no such findings. Are you saying, in effect, that's what was happening here?
Yes.
But it was shorthand.
Hang on a minute. They couldn't have done. They couldn't have embarked on that unless they'd accepted the submission that the FTT had erred in law. I think you're saying.
Well, I'm. Is that really what you're saying? That
What I'm saying is that the primary conclusion there is that, although not spelled out, agreeing that the respondent's argument, the Secretary of State's argument, that there was an obligation on the first tier tribunal to have undertaken the assessment for themselves, faces some difficulties. In other words, although not spelled out, they're saying that that is not the correct approach. But even playing devil's advocate.
But they expressly say they're not deciding that question.
Because they say what they go on to do is actually undertake the assessment which the Secretary of State wants them to do, and they reach the conclusion that there is no imperative ground.
Well, there's the 51. Yes. The submission at the start of 51, which I misread, but it is the Secretary of State submission that the FTT erred in not considering of its own motion whether there were imperative grounds. That's the submission. That's the error of law under consideration in 51, whether the FTT erred in not considering of its own motion.
Yes,
and they say we have some difficulty with that because Secretary of State never asked for any grounds and never asked the FTT to do it.
Yes. So the second part, when it talks about we find it unnecessary to decide the FTT might nonetheless have erred in law by not considering the issue, because we find that no such grounds exist. That is an assessment of materiality. The difficulty I'm having is that if this court was to find that that determination is unsafe, and it goes back to the upper tribunal, the outcome will have to be the same. The upper tribunal will say, well, the first tier tribunal, the Secretary of State offered no imperative grounds. What are we supposed to do? Where's the error in the judgment of the first tier tribunal? That is what they're trying to do. They're trying to, as it were, take on the second step so that they're covering all bases in case the Secretary of State says, well, why didn't you undertake the evaluative assessment for yourself? Which is what Ms. Everett seems to have suggested at 49. It's difficult for me to conceive what, if there is an error with the upper tribunal's determination, the matter is remitted for an error of law hearing before the upper tribunal.
Right.
Because it depends on, of course, the conclusions that this court reaches. If it's against us on ground one, again,
that's it. But if it's with you on ground one,
if it's with us on ground one, that means the first tier was correct to apply the provision as it did. We come to ground two, which is the imperative grounds consideration. Upper tribunal are left with asking themselves the same question, which is, what is the first tier tribunal supposed to do? Given the countless chances the Secretary of State had.
You're just saying this is too late, basically.
Precisely. They've raised it. They have the opportunity to raise it. Even at that stage, they don't say that this is the imperative public security ground. They simply say we're relying on an OASIS report, and you can decide for yourself if such grounds exist.
If we were to remit it to the FTT, would the Secretary of State be entitled to put forward arguments for saying it was imperative?
Well, they would then have what would probably be the seventh bite at the cherry, and yes, they would. But that would, in my submission, be unfair given the process that has so far followed, where they've had countless opportunities. But the appropriate course, if the court were against us, would be for remittal to the Upper Tribunal for an error of law hearing, because that seems to be Mr. Malik's argument that the Upper Tribunal has not properly assessed whether there's an error of law or not. We of course disagree, but we're saying that if Mr. Malik is correct, then we wouldn't ask for the court to remit it back to the
But
First.
if we did that and the FT and the Upper Tribunal concluded there was an error of law, what would they then do? Remit it back to the FTT?
It would depend on.
Yeah, I thought you were basically saying to us that
Too late.
it's all too late.
It is
We
all too
just-
late.
we
That
just
is what I'm
shouldn't
saying.
remit to anybody, because the secretaries, if imperative grounds have to be shown, the Secretary of State has had a number of opportunities now at different levels to raise them and hasn't.
I am saying that. What I'm saying is that if you're against me on ground one, the interpretation point,
That's it.
then of course there'll have to be a remittal, because we would have to argue the mid-tier serious grounds as opposed to imperative grounds. If the Secretary of State's construction is
Yeah,
correct.
there would have to be a
Yes.
remittal, but
So I don't want to tie my
on a
hands
different
in-
basis. I'm trying to understand how we'd get to a remittal. Of,
We don't on ground two, in my submission. We don't on ground two because, like your Lordship has said, they've had ample opportunity, they haven't raised it. And that's why I took the court to the decision, the skeleton.
But if we're against you, you say remit to the Upper Tribunal to decide it's an error of law. And then if they did decide there was error of law,
it will be up to them whether they remake it or remit it. But
Why
there are
would-
several permutations which
why,
could arise.
given that you point out that there was no, if the relevant test is whether there are imperative grounds, if I don't, but we're against you on that it's too late. I mean, why would we remit it to anywhere else other than the First Tier Tribunal to conduct a proper evaluation of it? As I just pointed out, otherwise you just send it back to the Upper Tribunal, and the Upper Tribunal says, well, what are we supposed to do with it?
Well, they'll be looking at the First Tier Tribunal's decision.
Where we know there was
Nothing advanced,
nothing in there.
and
So-
therefore
so why would we send it back to the Upper Tribunal on that basis?
because if I've understood my learned friend's submissions, he's saying that the Upper Tribunal missed a step by not determining whether there's an error of law. We're saying that if it goes back to the Upper Tribunal and they were required to retake that
why
step,
can't we decide if there was an error of law by the First Tier Tribunal? Could we say,
We've got the powers of the lower court.
we've got powers of lower court, so we could say that the FTT erred in law in paragraph 33 of its decision, in which it made the finding that there were no imperative grounds, erred in law and it should be remitted, at which point the whole issue could be properly determined with proper arguments and evidence as required.
my respect
Would that not be the fairest way to proceed if we were against you on ground two?
that, with respect, my lord, would be the most unfair way to proceed, because that would give the Secretary of State another opportunity when she's been given ample opportunities. And our position remains that if the matter were to be remitted to the UT, the Upper Tribunal, they would be looking at where the First Tier Tribunal has gone wrong, if at all. And they would be bound to reach the conclusion that this Upper Tribunal reached, which is nothing was advanced, nothing to hear, nothing
Right.
to
Well,
say.
for my part,
nothing
I'd
to
like
see.
I take your point, but for my part, I'd like to hear your submissions on whether or not the FTT erred in law.
No, my lord. Simply put, they haven't. They were not presented with any imperative grounds. As I've said from the outset, they can't pluck this out of thin air. They need to be told, well, this is the imperative ground of public security which the Secretary of State relies on, given that the burden is on the Secretary of State.
You say there was no error in paragraph 32.
Yes.
That's just recording that there was nothing. But when they went on to find no imperative grounds, you say that's a finding in paragraph 33.
Based on the absence of.
Right, well, if it's anything more than just, in a sense, repeating paragraph 32, then where's the reasoning, where's the basis for it?
Because 32 and 33 must be read together. They're saying that there is no imperative ground because none have been advanced.
Right.
The burden is on the Secretary of State, tribunal is an adversarial system, etc.
And we're back to that point.
Otherwise, as I said, the sort of fallback position or the consequence of all of this would be that the tribunal, in many cases, not just limited to these types of cases, would have to go fishing to see what aspects might or might not apply because a party hasn't advanced something. And that's precisely what the First Tier and Upper Tribunal have been discouraged from doing. That is why we have this system in place where issues are put forward.
Too late.
If you listen to that, in an adversarial system, if you have an alternative argument or a fallback argument, you're generally supposed to put it forward.
Yes.
And if you decide boldly to go into battle clutching one sword, don't expect the court to allow you to pick up a second one
Precisely.
a little bit later.
If you've put all your eggs in one basket, the tribunal's not going to bring you another basket, as it were.
Swords and
Right,
baskets,
good.
yeah.
Right.
I get it.
Anything more?
I think we get the metaphor.
Mr. Karim, we've interrupted you a lot this afternoon. This is quite a troubling case. Is there anything that you or Junior would want to say that we haven't allowed you to cover because you've been too interventionist? Difficult, isn't it?
My lords, my lady, I'm grateful. I don't believe I have any further submissions to make. I, of course, rely on the written pleadings. I should just correct one aspect, which is my reference or our reference in the skeleton argument to Regulation 27.5 and Schedule 1 not applying are on reflection incorrect. We do say that they apply, but they only apply if there are imperative grounds or enhanced grounds, etc., which we don't get that far in this case.
That's your point. Thank you. Thank you very much. Yes, Mr. Malik.
Lady Lords, I will seek to assist you on the two grounds in turn on the submissions that
Yeah.
Millard and Friend has made.
Going back to ground one, then you're going to
Yes.
start with ground one. The
Yeah,
point he makes about family member.
Yes. So Millard and Friend has taken you to Article 8 of the Directive and Regulation 27, and he says that his silver bullet point
Yes.
is that those provisions do not expressly exclude the possibility that a union citizen may also rely on their residence as a family member. That is, as I understand, his primary submission.
Well, he says that if he becomes he can become, if we look at 27,
Yes.
Sorry, you said Article 8. Is that? I'm missing
So 28, Article 28 of the
28,
Directive.
yeah,
Master
I
Society.
used
sorry. I mean, Regulation 27, isn't it, is where he
Yes.
really focused. And he says that where someone has acquired a right of permanent residence under Regulation 15 as a family member,
Yes.
that is sufficient. And provided they are an EE national at the date of the decision, even if they weren't EE national for the full period, they're entitled to the
Yes.
enhanced protection.
Of course, that is the point. And Millard and Friend says that these provisions, the regulation and the directive, they do not expressly exclude that possibility. That is what he says is a silver bullet. Now, the provisions do not exclude that possibility because there was no need for the provisions to do so. The premise on which Regulation 27 and Article 28 is drafted is that a union citizen who completes 10 years in the UK will have a residence in the UK, having union citizenship and exercising treaty rights for 5 years. B, acquired permanent residence, having union citizenship. And C, they would have resided in the UK for another 5 years with permanent residence, having union citizenship.
So when you say that's the premise, I mean that's you're stating the conclusion you want us to reach.
That in my submission, that is the premise that is apparent in my submission from the structure and scheme of the directive and the regulations. And the proper way in my respective submission to look at the question is this, that if the regulations and the directive had intended to allow a union citizen to rely also on the residence as a family member, then they would have said so within the text of the relevant provisions.
Well, family members drop out, having been provided for all the way through till we get to Regulation 27. They drop. There's no reference to family members at all.
Well, no express reference. to
Express
that.
reference, that's right.
But Mr. Curran says actually the plain reference to Regulation 15, unqualified, not just Regulation 15(1)(a), means that it by definition includes people who have acquired their right to permanent residence as residents under 15(1)(b). And if you wanted to exclude from the computation of these 10 years, the period within which they were busy acquiring rights of residence as family members, you would have needed to be specific about excluding it, because if you interpret the second bit of that consistently with the first bit in square brackets, you have no exclusions. So he says, no, you start from the wrong place. It's up to you to exclude it, not for him to point to words that include it.
Yes. So my submission is that in my submission is based on the reading of limbe in isolation. So you don't start in my submission from the words has a right of permanent residence. You start with the earlier phrase, an EEA national who has a right of permanent residence. It is the learned friend, I say with respect, like the Upper Tribunal, who seeks to read words in this provision that do not exist. The regulation and the directive, the provisions do not say that 10 years residence may include residence as a family member.
They don't say it can't.
No.
I think that's the problem with each of you saying you're trying to write something in. I mean,
Yeah.
I think we just have to try and interpret these words in light of the scheme generally.
Yes. That is right. But I'm not asking the court to read anything in the statute, in the provisions. But the submission is that I've shown you the part of the Upper Tribunal's decision where the Upper Tribunal added words in the legislation. So the submission that I seek to put forward in my submission is consistent with the structure and scheme of the directive and the regulations. It is not inconsistent with the language of Article 27.3, Regulation 27.3 and Article 28. And the submission against that submission, the submission that Millennium Friend makes, seeks to place family members in the same position as union citizens. And that would be contrary to the policy of the legislation, the policy which seeks to limit the highest level of protection only to union citizens.
No, I mean, he accepts that the highest level is only available to people who, at the time that the relevant decision is made, are union citizens. This is all about a question about how you get there.
Yes, I entirely accept that. But what I'm seeking to submit is that the submission that I make is more consistent with that aim, just limit the highest protection to those who are union citizens.
Does the wording of the directive assist you?
Well, there isn't. Well, the points that I've made apply to the language of the regulations and the language of the directive equally. So it's the structure and scheme of the directive and the regulations, and you have my submissions on Article 28.3.
I mean, during the course of submissions, I drew attention to recital 24 and the references to essentially providing protection based upon integration to people who were born and resided through their life. And I'd rather belaboured a sort of point about members of a family who could end up in a very different position by the happenstance of when they're equally integrated as far as they're able to be so from the start, and yet they have, on your interpretation, different outcomes depending on when their parents got round to getting them an EU passport.
Yes, so that is the
Come to that.
yes. No, that's the next submission that so Melanin Friend makes that point and says that the Secretary of State's case would create two different categories of union citizens, and the Secretary of State would treat union citizens differently. Yes, that would be the consequence of the submission, but it is the legislation that creates different categories of union citizens. Not all union citizens enjoy same rights and protections. This is the fundamental premise of the scheme. Some union citizens have right of permanent residence, some union citizens don't. Some union citizens have right of extended residence, some don't. In this particular context, the two classes are there's no proper comparison in my submission between two classes. Class A is a union citizen who has resided in the UK, having union citizenship for 10 years. The other class is a person who has not resided in the UK as a union citizen, having union citizenship for 10 years, but only during a portion of that 10 years. So there is a difference between two classes, and that is recognized in the legislation.
But I can see there's a difference, and that's really the question, because Recital 24 seems to suggest that what's important in deciding the degree of protection is the question of degree of integration. And they're given as a particular example people who've been born and have resided in a particular territory throughout their life. Well, the problem with your interpretation is that if we are looking at integration and people who've been born and resided there throughout their life, you have two people who, so far as they are able to do so, have done equally integrated, or both born and have both resided throughout their life.
Yes.
But on your interpretation, they get different outcomes because one of them is entitled to count more years because he had a passport for longer and the other one not. Whereas Mr. Karim's interpretation, they both end up in the same place.
Well, I'll make some very brief submissions about this when I address you on ground two. But when it comes to imperative grounds assessment, I mean, the fact that in the ultimate assessment of proportionality or links, the fact that someone is born in this country and has lived here throughout their life, that is a matter of sort of particular importance. And a person would be able to put forward that matter as a matter resisting deportation.
So you're saying that this reference is relating to the determination of exceptional circumstances or imperative grounds, not referable to the degree of integration.
Yes, because you'll see an express reference to where there are imperative grounds of public security. Should an expulsion may be taken against union citizens, and then these are the matters that one would consider. But it is not, in my submission, in any event objectionable having different classes of union citizens. This is what the legislation calls for. Miller Trend makes a submission about Regulation 27. Regulation 27 4A and Article 28.3, that there is no requirement of lawful residence for 10 years. and Miller Trend, you'll recall, emphasize that the word legally is missing from those provisions.
Yes.
Well, that point in my submission simply ignores the reality and the opening words of 4A. So you only get to 10 years residence if a person has permanent residence under Regulation 15. And in order to have permanent residence, you've got to have 5 years lawful residence. And once you have permanent residence, then your residence is lawful. So there is, for that reason, there was no need to include the word legally in the regulation or the directive. When I started my submissions this morning, it was put to me that the facts of the case were unusual, and Malord has made the point when Milana Trent was making his submissions too. I wouldn't disagree that this is an unusual case, but by no means it is a unique. It is not a unique case. Miladian lords may know this. They may know this already, that in India gained independence in 1947, but the Goa region of India
Yes.
remained part of the Portuguese Empire until 1961. And under Portuguese law, there are provisions that people born in Goa region prior to 1961 are eligible to apply for Portuguese citizenship. So you do get cases where a parent will have Portuguese citizenship and entitlement to come to the UK, but not the descendants. So the case is unusual, but not unique. Miller and Friend makes a point about Regulation 32.5. Can I just quickly take you to that provision, which is at page 64. Well, ultimately, following certain questions, Miller and Friend, with respect, was able to see the difficulty with the submission that he was seeking to make. But there is a rather fundamental difficulty with this submission, which is that this provision refers to a deportation order.
Yes.
There is no deportation order in this case. The Secretary of State has made a deportation decision.
Yeah, it's a
There
difference.
is an appeal against that decision that is pending. If the appeal fails, the Secretary of State will then make a deportation order. And if a deportation order is made, and there is a delay of 2 years in enforcing that deportation order, that would then trigger reconsideration under this particular provision. But the Secretary of State has no obligation to reconsider the deportation decision at all. If the appeal fails, the Secretary of State will be able to remove the appellant. So that is the rather fundamental difficulty.
So there has been a deportation order, but in the distant past, the appeal against the decision that led to the deportation order was successful. Is that right? Or maybe there wasn't a deportation order.
There isn't a deportation order in this case.
There have been deportation decisions in the past,
Yes, but not the
but not an order.
Yes.
Okay. Yeah, sorry.
there wasn't a deportation order previously because the appeal against the deportation decision
Succeeded.
was successful.
Okay, sorry, it's it's
The-
been a long afternoon. Thank you, that's very helpful.
So just moving on very quickly to the second ground. In my respective submission, what Miller and Friend says reflects a misunderstanding, a fundamental misunderstanding as to the imperative grounds analysis. Now, it's not the case that imperative grounds are identified in a statute or legislation or guidance. It simply reflects an evaluative assessment of all the facts, as Lady Justice Elisabeth Laing put to Miller and Friend, and Miller and Friend ultimately accepted that. Imperative simply means of vital importance. So a decision maker will look at all the circumstances of the case and will decide whether whether deportation is justified on matters that are of particular importance. Now, in this particular case, in my submission, there is a very strong case that deportation would be justified. Now, you have, and the reasons why that is so are set out in the Secretary of State's decision. So this is again, you'll read that decision in due course, but just to give you yes, you have, but just to give you bullet points. So very serious crimes. There are very serious crimes reflected by lengthy sentences. Mr. Borges is a persistent offender who continued to offend despite warning letters, the first deportation decision, the First Tier Tribunal's decision. Effect on victims. You have seen the sentencing remarks in the decision. There was a particular impact on the victim, and the decision letter also deals with the impact of this sort of offending on community. Mr. Borges played a significant role in the offending. Again, you have the sentencing remarks. There was significant degree of planning and preparation on his part. There is a real risk of reoffending and a risk of harm to public. Number of convictions. He has been convicted of 10 different offenses. There are 10 offenses. The Secretary of State's view that he represents a genuine, present, and sufficiently serious risk. So these 8 matters would go into an evaluative assessment, and in my submission would create a very real prospect that deportation would be justified. Now, when I was making submissions in opening, Milady rightly pointed out that Regulation 27(8), which you have at page 60, reflects Part 5A of the 2002 Act. So the submission.
I said it reflects it, but it's a similar sort of exercise.
It is a similar exercise, yes. But the submission that Miller and Friend makes is entirely inconsistent with that particular provision. You look at that provision at page 60, right at the end. And this applies also to Article 8 cases by way of Part 5A of the 2002 Act. The obligation on the tribunal now is to consider whether or not these matters are raised by the Secretary of State. So it's not enough in my submission to say that the system is adversarial. So this amendment and the legislation places an obligation on the tribunal to conduct an evaluative assessment of all relevant matters, paying particular consideration to those matters.
So is the provision in 27(8) a provision that wasn't in the 2006 EEA regulations? I mean, you may not know the answer off the top of your head.
Lady, That is my understanding, but may I just double check
Yes,
and,
of course.
and email
Yeah,
email that to
of
you?
course, that'd be very helpful.
Yes, thank you. So once the tribunal reaches the conclusion that there were imperative grounds, that the imperative grounds test applies, the obligation on the tribunal, irrespective of what the Secretary of State had said, was to conduct an evaluative assessment of all factors.
So that was the error, you say, now,
That's the
by
error.
the FTT.
Yes. And if you take the view that that is an error, there's no point sending the matter back to the upper tribunal to decide whether there was an error of law in the first tier tribunal's decision. I respectfully ask the court to say that there is an error of law in the first tier tribunal's decision. It wasn't open to the upper tribunal to uphold that decision, remit the appeal for a fresh hearing at the first tier tribunal.
So cut out the middleman precisely because there wasn't an assessment of any of this by the First Tier Tribunal.
Yes, and yes, and that would also be the case if I succeed on ground one, but of course the remittal would then be on a different basis.
Yes.
And do you want to say anything else about the interpretation of paragraphs 49 to 51
Yes.
of the upper tribunal decision?
So there was obviously some discussion as to what Miss Everett wasn't saying to the upper tribunal. Now, she is, as Melanchthon says, an experienced presenting officer, but in all likelihood, what she was saying to the upper tribunal is that, well, if you find an error of law, if you set aside the first tier tribunal's decision, then you can proceed to remake the decision yourself. And in doing so, she was saying, well, there is no further evidence from the Secretary of State, but the eight matters that I've highlighted were all based on the evidence that was already before the upper tribunal.
Yeah.
But if I'm wrong, and if Miss Everett was inviting the upper tribunal to conduct an assessment in any event, then upper tribunal should have rejected that invitation. Parties cannot confer a jurisdiction on the tribunal that
By concession or
by
agreement.
concession, yes.
Yeah.
So it's the statute that applies. Melanchthon says that paragraph 51 of the upper tribunal's decision is an assessment of materiality. If you look at how that paragraph ends, you'll see that if that is an assessment of materiality, it is fundamentally flawed. So you consider materiality in my submission by applying the inevitability test. You say that the error is immaterial because the outcome was inevitable.
Yeah.
You don't say that, well, the error is immaterial because if I was making the decision, I would have made the same decision. And that in my submission is an error. A question was put to me as to if the upper tribunal was actually remaking the decision, then what is wrong with the upper tribunal's decision?
Yes.
I have sort of highlighted 8 particular matters arising from the decision letter, and I've also taken you to the relevant considerations in Schedule 1. There is no engagement in my respective submission by the upper tribunal with those matters. So the point that I'm seeking to make is not simply a sort of technical.
You say there's no engagement with them. I mean, they say they've looked at it and they say they've taken into account, etc., etc. I mean, it's not right to say there's no engagement with it. I mean, you can say, can't you, that
Very sufficient engagement.
it's insufficient to satisfy the test which you've said, which is the decision of. Sorry, it's late in the day, I forgot the wording, but to say there's no engagement in the upper tribunal decision with Schedule 1, for example, I mean, that's going a bit far, isn't it?
Yeah. So, well, as Schedule 1 and the 8 matters that I've highlighted. So, if you look at paragraph 55 of the upper tribunal's decision, well, they say that, well, we have looked at Schedule 1 and we find that the case falls short of a case where removal is justified on imperative grounds. That surely is not
Well
enough.
short, you're saying?
Well short, yes. But if this was a remaking, then that, in my submission, there is, I say with respect, no engagement, for example, with.
But if they're remaking, it's just there's no sufficient engagement. I think you're probably saying, are you?
Yes, it's sufficient.
Yes.
It's quite cursory if
Yes.
they're actually remaking, because if they're remaking in circumstances where the FTT hasn't dealt with it at all, you might expect a bit more than there is in Para 55.
Yes, I mean, for example, where I invite Lady Lords to consider, where is the acknowledgement or assessment that this is a person who is a persistent offender, offended despite warning letters and the original decisions? What about the seriousness of the crime?
And also, like the FTT, they've ignored one set of offences and one sentence of imprisonment.
But what you're both saying, you're saying inadequate engagement, not no engagement. I mean, I think that's really the.
That's what you asked. That's what your submission is, isn't it? And what do you want to say, if anything, in response to the Volpe argument?
Well, that just does not apply. You have my submissions in opening. This isn't a case where there is a finding of fact, where you'll apply the due deference principle. There is the complaint is that the finding by the First Tier Tribunal is without any reasons. There's certainly a failure to engage with Schedule 1 matters by the First Tier Tribunal.
Okay. Well, I think we have your
you
submission.
have submissions, and this isn't paragraph 55 isn't an assessment of the facts. I mean, if it is, then it is wrong for a different reason, which is that this isn't the stage where the Upper Tribunal should be conducting a factual assessment.
Right.
Sorry, I just want. Can I just ask you about paragraph 56, because this is your submission about inevitability. They move from what they say in 55, which is it falls well short in our view, to saying the FTC would have been bound to have concluded.
Yes.
So that would be the right test for inevitability, wouldn't it?
Absolutely. So, but at 56, they depart not only, lady, from paragraph 55, as you say, but also from paragraph 51, the final sentence. It is, of course, true that this is the right test, but my submission is that they've got it wrong there. This isn't a case that is bound to succeed. You have my submissions on that in my skeleton argument. This is a case where there is a very real prospect of a different decision maker finding a properly directed decision maker finding that deportation is justified on imperative grounds.
So the reasoning is a bit inconsistent and wobbly.
Yes, it is with respect. Yes.
All right.
But the point is that whether it's the reasoning at paragraphs 51 and 55, or whether it's 56, I seek to impugn both points made by the Upper Tribunal. I'm very grateful for the patience.
So, well, we've taken a lot longer, and it's not, I think, in any sense, the fault of counsel.
No, I mean, I've just asked far too many questions.
No, it's
so
not the fault.
I apologise to you both.
It's nobody's fault. We were all confident that we were going to finish by lunchtime. All five of us.
Actually, I wasn't.
Oh, right. Well, many of us were.
I kept it to myself.
But only one of us was right. Well, we won't be surprised to hear we're going to reserve our judgments in this difficult case. We're very grateful to you for your work. Also, I think Bundle's well prepared, so thank you for that. Thank you for your submissions. We'll reserve judgment. In due course, we will send out, in the usual way, a draft of our decisions. That's to enable you to point out any typographical or minor factual errors and not an opportunity to re-argue the case. You'll bear in mind, of course, the rubric at the top of the draft judgment. It's confidential to those to whom it is sent. Any breach of that would be a contempt of court. When we send out our draft, please will you also, in addition to returning any suggested corrections, submit a draft order which reflects our decision. Insofar as there are any ancillary matters which are not agreed between you to go in the order, please also submit short written submissions on those points which we will resolve in writing without further hearing, and the judgment will be handed down electronically in the now customary way. Thank you very much.